Events happen that change our lives. Dealing with change is what we do. We discuss with industry professionals objective solutions to work through cherished items and family memories. When we go beyond the gavel, we provide tools and information to deal with these crisis times. Hi everybody, it's Shane Feely from Beyond the Gavel, also owner of Auction Solutions Inc. here in Omaha, Nebraska. I am very happy to have with me again on our show Monte Schatz. He's an attorney here in the area specializing in probate estates, and their whole office specializes in just about everything that you'd like to have done. Today we're going to talk a little bit in follow-up of the trust conversation we had the last time. And I'd like to start, Monte, if you don't mind, can we talk about the hierarchy of heirs? Who is responsible when someone passes away?
Yeah, well, that's determined partially by if there's somebody designated in the deceased person's will or trust, whoever they designate, if that person is able to, the person that we call the executor or personal representative in a will, or the trustee in a trust. Okay. And whoever that is that's designated in that is typically honored unless they are unable or unwilling to serve in that role. And if they aren't, or if they may have passed away before or not available anymore to do this, then what we do is typically you can go to statutes and there's a pecking order of when this will happen, and usually it goes to next of kin. Obviously, if there's a surviving spouse and they weren't named, it would go to the spouse next, then it would go to the children, and then possibly, you know, down the lineage of heirs and so forth. So it's kind of common sense. If none of them want to do that, then what you'd have to do is petition the court or get an agreement from all of the heirs to possibly name another individual, or if a bank needs to be involved in that, perhaps have a bank named as the trustee or personal representative, a trust department. Okay,
so if I have an ill husband and I have 3 or 4 little children and a house, and maybe the husband had some investments, and I'm the only person that he's ever been married to, can someone from the outside claim conservancy or come in and file paperwork to manage the estate that will eventually happen upon his death?
Well, typically, again, if the person has a will in place and so forth, or a trust in place, usually that document will be honored, okay, unless somebody comes in and contests it. So the situation that you run into sometimes is the surviving spouse may be a great parent and so forth, if we're talking about young children and so forth, not of adult age or age of majority as we call it. Sometimes that surviving spouse may not be real good at managing finances. Great parent, not so good at finances. If there is nobody designated, again, typically they're going to look at the surviving spouse first. But if that person does not want to handle it, or if there's extenuating circumstances where somebody has concern about the financial responsibility of this person, you might be able to have a conservator intervene or have somebody else designated as a trust if there was a trustee, if there was a trust in place, and there might be an alternate trustee provision in there. And if that surviving spouse in this example, for example, in this case, is willing to give up that role, then somebody else can assume it. If not, then we may get into the contested trust or contested estate scenario.
Oh, that sounds like a whole lot of fun.
Yeah.
So if you have adult children that no one's seen for a while, and you're not married, what would the hierarchy be then? Round up the adult children, or would it be your parent, or?
Typically, if there's adult children involved, then there's, again, we're talking about the surviving spouse, right? The first spouse.
Correct.
Thing. Yeah. So again, the pecking order is going to be if there was nobody designated in the will or trust, it's going to be that typical next of kin, which they would look to the adult children and so forth. So that's kind of your priority. Okay. And if you think about it, the law kind of reflects the common sense. Usually you honor, blood is thicker than water, right? That type of situation. However, there are times when you run into families where there isn't really a good set of choices for responsible parties. If you don't have the kids that are very financially responsible or have some background in this, or at least the fiscal and emotional maturity to handle this,
Right.
then you may have to look to other sources to handle this. Now, a lot of that's going to depend upon how the surviving parent, if they have capacity, if they're going to resist and fight this, and similarly, is the other side going to dig in their heels, namely the children. This is one time when the generational gap might blow up in your face, so to speak. But that does happen, and at that point, then, if that you have to invoke the court's assistance in determining that and so forth, and nobody can reach an agreement on that, typically a court's going to look to a neutral third party, maybe a more responsible, more remote relative in the family that might do it, might be a professional like an attorney or accountant or some financial advisor that might do it, and also might be a bank trust department or an independent trust company that takes over. Somebody that's neutral and doesn't have a dog in the fight, so to speak.
Yeah, absolutely.
Yeah.
Sometimes that's better.
Yeah.
Well, if a trust or a will does have the opportunity or the chance of going to a battle, how do you try to avoid that in your offices?
Yeah. Well, the first thing I do, I mean, there's legal answer and the practical answer, and I always try to give them the practical answer, and I challenge the people involved in the estate, the heirs or the beneficiaries of the trust, and I say, who do you want this estate and trust to go to? Do you want it to go to your family members or who the person that passed away intended it go to? Or do you want it to go towards paying your attorney's kids' college tuition, so to speak? And I say that tongue in cheek, obviously. But the reality is if it, what I tell people and clients is pick and choose your battles. We'll take up anything you want to contest in this thing, and if there's a real problem, sure, we'll go to bat for you. If we need to go to court, we'll go to court, But I always view that as a last resort. There's so many places you can go before that.
Sure.
Informal meetings with the heirs, and sometimes the toughest thing to do is, at least in my practice, I found that transparency is critical. So I try to get all the family members together, even if it's a very difficult, intense situation. It helps me see what the dynamics are
Sure.
of all of the individuals in the room, what's driving this contentiousness among the family members, and what potential do I have to relieve that short of going to court. We'll see if they can talk it out, and if they can agree something informally, then hopefully we can move forward, whether that's designating who the trustee should be, if that's going to be a place of contention, how the assets are being distributed and so forth. Is there questions about the validity of the trust? Was one family member favored over the others? Why? And those types of things. But we'll try to work it out informally. If that doesn't work, then what I suggest is that perhaps we might consider mediation as an option, estate mediation. This is mediation is getting to be a growing area in the legal arena and in several areas of law, but also particularly in estates. As you know, we're having this huge transfer of wealth from one generation to the
Correct.
next, and inevitably just actuarially, you're going to have a certain percentage of those estates that are going to be contentious and contested and difficult. And so litigation is expensive. If a court case and a contested estate case goes any amount of duration in court, the main heir is going to become the court system and the attorneys working on it, frankly. It just
can be very expensive.
It can be very expensive. And so we suggest mediation as an option, and what that is that all the parties agree to, in a contractual agreement, to sit down with a neutral mediator. Each one of them gets to express their concerns. It's not binding. Again, it's a process, so you hope that if they can walk through it, it'll help them. The advantage that mediation gives you that going to a full-blown court battle doesn't take into consideration as much is people not only get to talk about what their position is and why they should feel this particular outcome occurs in an estate or in a trust settlement, but they get to talk about their feelings. I feel it should be this. Now, some people would go big deal. But what that does is that avoids all the technical civil procedure maneuverings and rules of evidence and so forth, and people get to just lay it out on the line. I'm really upset that my brother Tommy is getting 10% more than the rest of us because I feel that. And sometimes that might click with another person that's in that session,
that makes
and they may
sense.
step back and think about it. It can also have the opposite effect.
Yeah.
It also may just, picture your kids going at it when they were in junior high. It may just antagonize the situation and escalate it, but hopefully that's where the mediator can come in and facilitate what perspective they're coming from, and help the parties get everything on the table.
Sure.
And so if you do that successfully, and let's say you have 2 or 3 days of a mediation session versus extensive time in court proceedings, you may come out well ahead financially, and hopefully there's less emotional and legal bruises left after the fact. Because the other thing about mediation is, to a degree, it's empowering the parties to come and reach a settlement or an agreement, as opposed to having a judge come in there and tell them this is how it's going to occur.
Court ordered, yeah, that's always
Yeah.
the best way.
Yeah.
Not.
Yeah.
Well, so, yeah, I know.
Yeah.
We see it a lot in our business. And whether it's a business liquidation or someone has passed because and they're going to liquidate the business, we find that some people were promised something, but there's nothing written down. So we list everything. At least you have a complete listing of what was there when we sell. But again, sometimes items are taken out of that before the auction happens, because Tommy was supposed to get this tractor and he's due the snow blade, and that Bobcat belongs to Freddie. But in the grand scheme of things, it sounds at that point like they've all worked it out, rather than the ones that we've done auctions where you have to put it all online and every family member gets to bid, and then they pay, and then they pick up what they won. It's a very fair way to do things, but it avoids going to court.
Yeah, it does, and you bring up a really interesting point about specific items that where people thought, but it was not put in writing in a will or in some type of testamentary list or some kind of a letter of proof of specific items that they wanted to go to people. Now, I can't emphasize enough, if you have those particular items for sentimental reasons or otherwise that you want to have go to specific heirs, whether it's family members, friends, charity or whatever, it's really important that those personal items are memorialized either within meaning written in to the will or to the trust, or that there is a list made that's incorporated into the trust or will and attached to that instrument that gives a clear outline of what items should go to what individuals. There's nothing more frustrating than seeing a family blow up emotionally and perhaps financially over an estate that might be of considerable size, and they're fighting over the Hummel figurine collection that might be 1% of the value of the estate. And I'm not being dismissive of the sentimental impact of it, but that is a problem that could have been so easily avoided with a proper listing and identification of items.
Absolutely, that makes perfect sense.
So that's really a critical thing that people need to be aware of and think about, and talk to their attorney about.
And here's something that we've had happen before. We were ordered to sell a business liquidation because there was a decedent, and they'd had a partner, and the partner had equipment that they wouldn't bring back. He said I could have it. Well, they hadn't paid rent, they hadn't paid the taxes, they hadn't paid the repairs, so there were repair bills on it as well that the family would be responsible for. And we've had to go out and seize that with court orders. And thank goodness we've got good attorneys in town who can make that happen in a very short time. Otherwise, it can really hold things up. Right.
And like I said, that's another important aspect of trust and wills. Now, a majority of Americans are, working people that come in and have a salary typically, or some kind of commission structure, and they're working for somebody else, right? And most of their assets are their house, maybe an IRA or 401k balance. But when you throw in somebody that passes away that has particularly a closely held business, that's where the planning just becomes critical. We talk about business planning or business succession. You know, that's an important discussion where somebody's thinking of selling their business during their lifetime, but it becomes even more critical. The discussion of business succession and estate planning are inseparable at that point if the person owned or held their interest in the business until their death.
Sure.
And that can become a source of real contentiousness, especially if you have a situation where one of the family members or two of them, typically a child or children, that are actively involved in the business, and then you have other children who have gone on and taken on other careers. And yet, understandably, the person that owned the business wanted to be fair to all the children. Well, being fair to all the children might mean if you don't have plans in place how to do that, if the children have to assume the business and make a living, but they have to pay off the other beneficiaries to buy out the other shares,
Right.
that can create a real liquidity crunch and a real burden on the business and its ability to sustain itself for the next generation. And Shane, I'm sure you know from all the auctions you've handled and the other business affairs you've been involved in, the statistics of a business going into a third and fourth generation are not real favorable.
Oh, absolutely.
And a lot of that is because of the lack of planning. We tell people, as crazy as it sounds, because we know it's very difficult for, you know, when you're at the front end of a business of thinking about an exit strategy. But we really emphasize from the time we form some type of entity form, whether it's a partnership or a limited liability company or an S corporation or whatever is recommended for that client, we really try to get them thinking, okay, let's structure this in a way now. We know you've got a lot of hurdles to leap before you get to the end game of selling the business or passing on to the next generation. But let's start thinking now and planting the seeds to when that business matures, and so we can cash it out in a reasonable way or pass that on to the next generation. Sure. And we know a lot of things can happen in between, but it's just kind of having that foresight for when that inevitable event occurs, which is either liquidation of the business because it didn't work, or hopefully, passing of the business to somebody, whether it's somebody outside the family or a family member,
Sure.
so it can continue to succeed.
Well, and I know sometimes they try to put the next in command, who may not be a family member, allow them to buy it or the employees to buy it and
Right.
things like that. And that can be a little difficult too, just because of the mortgage as well as their day-to-day operations. And if you haven't run a business and you're not really strong in that capacity, it makes it a little tougher. There's a lot of lessons to learn real quick.
Yeah, and yes, and particularly in today's environment, there are some businesses, as you know, and I think they're the exception, not the rule, that have huge profit margins and might have a very nice cash reserve to be able to continue this if it goes to a next generation and has to buy out other family members or key employees or however that business arrangement may be structured. But I think the reality is more and more businesses, to stay competitive, have to operate on a thinner and thinner margin.
Absolutely.
Well, now you got the thin margin of profitability. You might have a nice reserve if a death event occurs in one of the principal owners, but you might not. And then if you don't have those tools in place, be it life insurance, a reasonably structured installment arrangement where the purchasing member of the business party in the business buys out the selling members, or there might be an ESOP, employee stock option plan in place that allows for that. But if you don't have some tools like that in place, it's a formula for disaster. It makes it pretty precarious to make sure that succeeds for another generation or for the next group of employers that take it over.
Yeah, that's really critical.
Yeah.
How would that affect us in like an agricultural environment where one person has been running the operation with dad and mom, and all of a sudden they're the one? In the old days, dad would liquidate everything and let that individual buy all new equipment, which increases their debt substantially.
Right.
And makes it a little tougher for them. How do we how do we work with that situation?
Yeah, and you point out one of the, I mean, the concepts and the principles occur in all kinds of business lines, but you've really identified one of the most critical and most pervasive type of problems we have, namely the agricultural sector, you know, the preservation of the family farm, if you will. And family farm takes on a lot of dynamics today. I think, you know, people used to think of the traditional family farm as it was ma and pa and, you know, 3 or 4 kids. And there's still a lot of that, but now with more sophistication, that family farm might mean, you know, a limited liability company, structured as a corporate farm entity. It might be all family ownership, but that level of sophistication becomes more and more. But where it really has become critical in recent years is, of course, the previous decade, before this one, you know, we had a tremendous run in price, you know, farm valuations. And when that's going on and you haven't had an immediate sale, I remember the immediate response I would always have with the farmers, oh, I'm not going to have an estate tax problem. I'm not going to hear, you know, my land isn't worth that much. And then we sit down and we look at the, you know, the recent farm sales and so forth, and we start taking that times the number of acres they have, and they say, ooh.
Had no idea.
Wow, yeah, had no idea. It's the classic, you know, cash poor, asset rich story.
Right.
You know, it may not be thrown off a lot of cash, and they may not be realizing it. And if they are, they were probably, you know, to save some taxes, putting up the new Morton building or buying that new equipment they needed to, and so forth. And like I said, all of a sudden now you got this dilemma, because let's say you got mom and dad, the first generation or maybe the second generation, and they have all this farmland. They have 4 kids. You know, one son has been real integral in, basically he or she stayed on the farm and helped mom and dad maintain it. You know, and unfortunately, in some ways, you have a lot of handshake deals between the parents and that particular child, and you have no formal agreements in place, and then it's like, well, and then all of a sudden you have the event where the first parent and or the second parent dies, and now it's clear, and usually is, you know, there's a will or trust in place that clearly indicates that they want the farm to go to this particular person, but they want to equalize the benefits for the other 2 or 3 kids that didn't stay on the farm. Well, then you get into the classic argument of, well, you know, mom and dad, you went off and chose to get your college degree and you're making your livelihood. I was sitting here being an indentured servant to mom and dad with the hopes of, you know, taking over the farm. I mean, you know, and I'm using the kind words here, okay?
Well, I've heard a little of it.
The language is a little more colorful than that sometimes, but all, you know, all putting that all aside though, then that's where the planning becomes so critical, because you're fighting 2 elements there. You're trying to get, you know, equality among the heirs, and you can't discount that. I mean, that's called testamentary intent. That's what mom and dad wanted to have happen. You know, that's a critical piece, and then the, you know, and in order to do that, you got to have some kind of sustainable buyout, whether that's through life insurance, which hopefully they may have had. You know, and everybody grits their teeth when they write out that premium check. I mean, I understand that, but it's probably one of the, you know, the most usable, successful ways to make sure there's a buyout, because the insurance goes to the successor in interest. There's agreement in place, a buy-sell agreement, where he or she buys out the other siblings. The siblings have their cash, they're happy. The child that stayed on the farm and was active in the management and the success of it owns their land, and they can go forward without having that, you know, that big squeeze on their margins, because they're paying out of cash, and hopefully the price of commodities, and of course we know where that's been going lately too.
Pretty pitiful lately, but
yeah, margins are pretty tight again.
Yeah,
you know,
were.
for sure. So you know, it's really important to have that planning in place. So you got those dynamics, the equalizing. Then you have, even with the increased exclusion that we now have with the federal estate tax, which is 11.4 million, round numbers, and it's going to go up here. Well, I guess we are in 2020. It's about up to 11.6 million now, so it adjusts each year for inflation. But got to be careful about that you don't fall asleep, because you got to keep the federal, you don't want to have an estate tax lien on your property or have to make an installment payment
boy.
to the federal government on that, because that's a really burdensome amount of money, amount to have to pay. But the thing that any business, farm or otherwise, can't rest too much on is that, you know, there's permanent estate tax changes. Well, yeah, there's permanent estate tax changes until 2026. And then that increasing 11.6 million going up each year for inflation stops, and we go back to the $5 million amount that we started with. Well, you know, you're a farm with so many acres, there's a good chance you might be above that 5 million, and even if you can exclude it for 2 spouses, which you double that amount, 10 million, it's not that unusual to be able to have a $10 million farm. And if you want to pass that to that next generation, how are you going to do it? Yeah. Well, you got to have these plans in place, like buy-sell agreements, either through the use of insurance, installment agreements. The IRS does give some valuation breaks to closely held businesses. It's called special use valuation. It helps, but if the value of the property that's subject to estate tax is any amount, you're still going to run a pretty good risk of it being, even with the reduced valuation, still being higher and above that amount.
Monte, hold that thought. We'll be back. Our next session will continue about ag and how that affects us when we have a decedent and one family member taking over the farm. Ladies and gentlemen, again, Beyond the Gavel, Monte Schatz. I'm Shane Fielding. Thank you.